All right, we're going to talk today about AI and patents and trademarks for AI software and apps. I've got the expert in this, Wayne Carroll. He's going to talk today about the importance of securing trademarks and trade secrets, big lies and patents, and how the law has completely changed, and how there's a lot of ideas that you think you can do, like can you mail yourself to prove it patent? Can you patent an app? If it's so, how do you do that? When should you be talking about patenting your app? When it's too late to patent an app? And is AI software able to be patented, and how? And some of the big things that you can do to protect yourself and your business. All this on True Law Stories. But of course, this is brought to you by videocasestory.com. If you're looking to grow your law firm, your business, the best way to do that is through your client stories. We'll help you collect them, craft them, and create an entire YouTube strategy around that. Go and find yours. Go to videocasestory.com/finder. All right, let's get started. Tell us a little bit about your business.
All right. So we focus on helping companies develop a good strategy and implement that strategy to secure their rights for their inventions, their brands. Those are the two main things. We also help with contracts to secure their trade secrets, things that don't make sense to patent, and copyright. So we focus on securing those rights because you really need to do a few things, sometimes more than others, to make those rights exclusively yours.
Gotcha. Yeah, I'm sure a lot. I mean, I know there's just tons that goes into IP, intellectual property, trademarks, copyrights. It's such a vast world, but it's essential in business. And uh, what do you think are the biggest like mistakes in people's heads when it comes to their business and intellectual property?
Well, there are rumors out there that are maybe partially based in fact, or maybe were based in fact in the past, but aren't now. One of those is if you invented it first and you could prove you invented it first, you've got the invention secured. That is absolutely false.
Wow.
Because partly it's because the law changed, but it was never a good strategy to say, oh, I don't need to file a patent. The law changed in 2013 to make it so that there is no priority based on first to invent. It is only first to file. So there used to be this provision of if you invented first and then two people filed, you had to be one of those. Then you could contest and say, no, I invented it first, and prove who actually completed the concept and could prove that. But now that's gone in the US. And pretty much that has been the way we harmonized with the rest of the world. So the rest of the world says that's like a crazy system trying to figure that. Let's just go with who filed the patent first.
Yeah.
So now that's the system. So mailing yourself something to prove you invented it on this date, it was never a great strategy, but I've heard that over and over. Those don't do anything for you.
Yeah.
And then there's deadlines that people don't realize. Once you make it publicly known, it's too late to get patents if you haven't already filed. In other countries, the US, you only have 1 year, but there's a caveat there that we can discuss at another time, reasons why that's even highly risky. So,
and so, there's a lot of ideas around what you can patent and what you can't. Tell me a little bit about the story you have about someone who was about to spend a lot of money on patents.
yeah. So someone came to me for a consultation, and what we do first is strategy. Understand where your rights really are right now, and what can be done to properly protect those. So it was a software project. He had launched an app, and he actually said, well, another attorney helped me file a provisional application. Provisionals are temporary. They last 1 year and then expire. And he hadn't done the next step to file the non-provisional. So that was actually passed. And he's like, well, I want to resurrect this project and start again. So, I asked him a few questions. One of them was just around what I was talking about, was when did you launch it? What's the date in the App Store that shows you launched it? And it was more than a year before that first provisional application was filed. So his own publication of launching it in the App Store would make it so that he can't get a patent. And he couldn't when he first filed. He had already missed the deadline with the first filing. And he was coming to me to say, let's start over, let's go for this project. And, patents are typically in the tens of thousands of dollars. So it's not a small undertaking. Even large businesses take that kind of money seriously.
Yeah. No. Yeah.
So,
and there's risk at taking. I mean, because you won't necessarily always get the patent, will you?
right. So,
Yeah.
and that's why we do the strategy first. We do research. So, just talking to somebody, I can often find out, do we have a major block where we really have to change directions? And so that was one of the ones. So he didn't go forward. He could change his business strategy because a patent wouldn't have worked. So he could have, and patents take years typically. You can pay extra to get it expedited, and then you might get it through in 1 year. So think of following a business plan for an entire year based on something that isn't going to work.
Wow.
So it's not just what he spent on legal fees. Small businesses, what they're patenting usually is the core of their business. Rather than a big company where it's like, yeah, we could enhance this, we could enhance that. And each patent is just a small step forward for them. But for a small business, it's central to the strategy. And it doesn't mean you can't have a business, even with a new product, unless you have a patent. You can definitely, use strategies, things that make sense without a patent. Sometimes it makes more sense to do the patent. Sometimes it makes less. So our first step of what we do is strategy, because it's not just what you're going to spend on legal fees. It's what is your business plan around it? Because these are all assets, especially for small businesses, where whether or not they have exclusive rights should change what they do in their business plan.
Is it usual to be able to patent an app?
It really depends on some things. So patent law, especially around 2013 when the law changed, 2014, there was a Supreme Court case that basically made it really easy for the patent office to reject software patents. We've come back from that, and there's been more guidance and more openness for it. And now with AI, the patent office has recently signaled, releasing things saying we want to grant patents on AI. It isn't just we're going to reject it all, but you do need to show what your app does. Well, it has to be something that's considered new, never published before, and not obvious based on what's known. As well as we need to show what is actually changed in the real world. Now, software, a database that's now much more organized and much more useful, is a change in the real world. But those are the things we got to talk about. And sometimes when people come to me with software or inventions, they're still at a very high level. And we need to say, okay, what are the servers you're interacting with? What are the data sets? What are you doing with those? What's the output? How can we show that you've really transformed something? You accomplished something. Occasionally apps actually change the way the phone works, and that's very useful. If we can describe it that way, you're doing something with the phone that wasn't possible before because nobody had programmed the phone to do that. So
Interesting. And, you know, at what point, if I'm building an app, should someone like this be coming to you?
So I definitely want to talk to them before they release anything. Because as I talked about, your own release can prevent you from getting a patent. So before they release anything, and early in the stage is often good. And there are a lot of times I do talk to somebody and it's 6 months or a year until it actually makes sense to pull the trigger and start the patent process. And I'm okay with that. And I keep in touch with them, and I would much rather that be the case than they call me and they say, 11 months ago, we launched this app and people love it and we should get patent protection. I heard I have a year. Can we get this done? So maybe so, but then we don't have the chance to do the proper strategy, which is doing research to say, patent research to say, is this patentable? What are we working against that's out there? And sometimes it makes sense to even do that research early on. There's different ways we can do it, but one of them is to really focus on what is the industry doing right now. So you can see, is there what they call white space, where, things that people aren't patenting around, and you kind of get a look through patents of what your competitors are doing, what they're investing in R&D, what direction they're heading.
Interesting. And so in the case of the gentleman that you mentioned, if someone's like past the year for the app and they can't obviously get a patent, how would you suggest adjusting your business, changing your business, protecting yourself?
There's two things that even if you aren't getting a patent, you want to consider and really should look at. Is one is trade secret. What is not easily known? And so a trade secret is anything that is valuable, at least in part, because your competitors don't know it. Something that your competitors don't. That includes things like your list of vendors and your list of customers, your sales lists. When we're talking about software, sometimes there's annual renewals. And so if your competitors had your list of here's all the customers and here's when they renew, that would be gold for them, because then they could target your customers a month before they renew, or whatever is the right time frame to make a change decision.
Yeah.
And so you want to keep that confidential. We want agreements with your employees and anyone who has access to that, even if it's vendors and such, that they're going to keep it confidential. So that's what you need to do to have a trade secret. You need to identify what it is, get agreements in place that it's going to be kept confidential, and have reasonable security. So you don't just open the door, anybody can click their way through into my customer list.
Yeah. No,
with all that data.
Yeah. Those are such important things to protect.
The second way is copyright. You can copyright software. So copyright covers the creative expression of an idea. So when someone writes a book, it's their creative expression, whether it's fiction or nonfiction. And so software has been considered to be creative, at least have some creativity in it. So you can copyright your code. You can actually copyright while still holding the code as a trade secret. So there's ways we can actually file a copyright with a redacted copyright or source code.
Gotcha. Okay. Yeah. And so what about when it comes to if you use AI to create the software?
That's a great question. And that is one that is developing. So some of the earliest things that came out was if AI does the creative part. So who the creator is right now has to be a human. So considering now, I believe we're going to be able to, and I think we can at this time, co-create with AI, but, and I think that's probably what pretty much all programmers are going to. Programming has been, there are modules you don't write because they're known and they've been out there and you just license them from MIT or wherever. And so you just plug in these things. And then what you're doing is putting these things together. So with AI, we're actually going further up a level in that you can help design a system and have AI be the one who writes the code. So in a lot of ways, it's similar to what's been done before of licensing different pieces of software. And we can also file copyright based on the look of the output. The question does come down to, especially right now, is who made the creative decision in that software.
Gotcha.
So if you leave it completely up to the AI, then you've got much less or maybe not even any. And there's been some, I'm trying to think if there's been any test cases in copyright. In patent, there have been some test cases around the world that attorneys and academics got together and created an organization and got an AI to actually invent things completely on its own and submitted an application and see who would reject it and who would accept. So,
interesting.
most the jurisdictions around the world rejected it. A couple accepted it, but it was kind of it's not like that invention was super valuable. It was about testing the system. See what is going to happen. Let's find out the state of the law right now. Then we know what to work from. We know where we're at, so we know what to work from.
Gotcha. It's fascinating. And so, what type of advice would you give out there to someone who is building software right now with AI?
Thinking about what creative ideas are you putting into this? And that might be, it would be good if you can separate that and what you're putting into AI. If you have all those saved, that might be useful. There's not a lot of case law yet around it, but that's one of the things I would suggest is save those logs of what you asked so that you just have the evidence of what did AI create? What did you create?
Awesome. So, and if someone does need your help, obviously you've got a podcast, Leveraging Inspiration. We'll leave some notes to it, but what's the best way to get in touch with you?
I also have a website, and it's inspired-idea-solutions.com. So I've named my law firm Inspired Idea Solutions. From that website, you can click on a link for a consultation and get that set up. You can also call our main office and set up an appointment through our receptionist. And our number is 480-741-2440. We're based in Arizona, but we work all across the country, and we work with people in other countries to secure their U.S. rights. And I do work with attorneys in other countries to secure my clients' rights in those countries.
Awesome. Yeah. I mean, it's evolving stuff. It's fascinating stuff, and it can cost you or make you a ton of money.
Yeah.
That's fantastic. Well, Wayne, any last parting tips before we go?
One thing I didn't mention that I wanted to around trademarks is there's also an idea out there with trademarks is, well, if I used it first, then I'm safe and I don't need to file a federal trademark. And I would say that's not entirely accurate. And part of it is kind of like saying, well, I don't need insurance for help because if I do get sick, I can just pay for it. We get health insurance because for trademarks, if somebody else files a federal trademark, but you used it first, you can contest them and win through a lawsuit that's going to cost you 10 times or more than filing
Gotcha.
and getting the trademark yourself.
Awesome.
So,
Yeah, that's fantastic advice. So we'll put a link to your office in the show notes. Obviously, a link to your podcast and a link to your book. Mr. Wayne Carroll, thank you so much for being on True Law Stories.
thank you, Ian. It was great to be here.
It was great to have you. And thank you all for making us part of your story. This has been Ian Garlic in True Law Stories.